Sorry, can you speak up a little?
Sorry, yes. We've already looked a little at what amounts to a turpitude, and I've made the point, I hope, that the authorities have required criminal or moral responsibility, legal or moral responsibility. But the question of what amounts to a turpitude was considered and particularly focused on by Lord Sumption in the case of the laboratoire and apotex. And in the absence of criminal and moral responsibility in this case, the defendants seek to apply the term coined by Lord Sumption in that case, quasi-criminality, and to say that a turpitude need not have criminal or moral responsibility as long as it is quasi-criminal, which they say is an act for which invokes the interest of the state. And my submission is that it is important to look at the context within which that term of quasi-criminality was coined and consider whether that is right, that it can be unhinged from the requirements of illegality or immorality, which we say are inherent in the policy of extirpation. And so if I ask you to turn to the laboratoire and apotex, and that's at tab 25 of the Bible.
Electronic page number.
I'm going to take these to page 568 of the judgment in a moment, so as well to open there. Mr. Warnock, of course, took you to some of the paragraphs in this judgment, and I'll take you to some further passages. But the overarching point which I seek to make about this, the proposition I seek to write, is that le laboratoire is not authority for the proposition, as the defendant's argument suggests, that the illegality defence can arise where the claimant was not responsible for his acts and was neither criminally nor morally culpable. To the contrary, Lord Sumption's speech suggests that attribution of culpability to the claimant is an essential component of the defence. And there's nothing in Lord Toulson's judgment in this case, nor in the subsequent case of Patel and Mirza, to suggest that that is no longer good law. The starting point, Lord Sumption sets out, in fact it's at paragraph 13 of the judgment, at AB 562, so the authority funding 562. He sets out the classic statement of the illegality defence from Lord Mansfield in Holman and Johnson. No court will lend its aid to a man who founds his cause of action on an immoral or an illegal act, if the cause of action appears to arise ex terpe causa or the transgression of a positive law of this country, the court says that he has no right to be assisted. And he returns to this founding principle, this classic statement of the principle throughout. And he begins his question specifically focusing on what is a turpitude, what can amount to a turpitude, at paragraph 23, page 568 of the bundle. The paradigm case of an illegal act engaging the defence is a criminal offence, so much so that the modern judicial analysis deals with the question as if nothing else was relevant. Yet in his famous statement of principle in Holman and Johnson, Lord Mansfield spoke not only of criminal acts, but of immoral or illegal ones. And having noted that, he asks himself the question, what did he mean by this? I think what he meant is clear from the characteristics of the rule as he described it, and as judges have always applied it. It's part of my submission that it's inherent in, or it's implicit in everything that Lord Sumption says, and explicit here, and again at paragraph 29, that he considers what is meant by turpitude. It is clear from the characteristics of the rule as Lord Mansfield described it. he goes on to consider that it must also engage the public interest.
Well, hang on, not also. That is him glossing or explaining what immoral or illegal means.
Yes, it must also, well...
No, not also.
I
Must therefore.
think if we can go on...
Sorry.
Yes, he meant acts which engage the interests of the state, or as we would put it today, the public interest. The illegality defence, where it arises in the public interest, irrespective of the interests or rights of the parties. It is because the public has its own interest in conduct giving rise to the illegality defence that the judge may be bound to take the point of his own motion. And he looked then further at paragraph 25 of what these can include, which are not criminal acts. And paragraph 25, the ex turpi causa principle is concerned with claims founded on acts which are contrary to the public law of the state and engage the public interest. The paradigm case is, as I have said, a criminal act. In addition, it is concerned with a limited category of acts which, whilst not necessarily criminal, can conveniently be described as quasi-criminal because they engage the public interest in the same way. He says, leaving aside the rather special case of contracts prohibited by law, which can give rise to no enforceable rights, this additional category of non-criminal acts, giving rise to the defence, includes cases of dishonesty or corruption, which have always been regarded as engaging the public interest, even in the context of purely civil disputes. And he has some anomalous categories of misconduct, such as prostitution, which without itself being criminal, are contrary to public policy and involve criminal liability on the part of secondary parties. And the infringement of statutory rules enacted for the protection of public interest, attracting civil sanctions of a penal character. He's not in my submission, in that paragraph, obviating the need for either a moral or a legal dimension. And he goes on to say, in paragraph 26, that there are dicta which suggest that the ex turpi causa principle may be wider than this, that it may be engaged by a purely civil wrong, such as a tort or breach of contract. The clearest and best known of them is Kennedy J in Burrows and Rhodes. Burrows and Rhodes is the case, you may remember, where the defendant wanted to invade a territory and induce the claimant to join their tour, saying that it was lawful, and he joined the party on that basis. He suffered injury, and when he returned, he was liable to criminal punishment under the Forceful Enlistment Act, because he had joined this illegal tour, and he claimed damages, and the defendant sought to strike him out on the basis of his illegal conduct or act. He carries on, having considered that, and the defendants were unsuccessful in applying the illegality defence in Burrows and Rhodes because they had induced the claimant into taking part in that, and also because he did not have any knowledge that he was entering in doing something that was unlawful. But Lord Sumption says, note that there is a dicta in there from Kennedy J that no claim could be damages could be founded on an act if it is manifestly unlawful, or the doer of it knows it to be unlawful, as constituting either a civil wrong or a criminal offence. So for his purposes, he's saying there are some dicta which suggest it may extend to a tortious civil wrong, but certainly within that, there's no suggestion there that it would lack the necessary ingredient of culpability. And he then goes on to say, the only English case which was cited as supporting that proposition, in fact related to a criminal libel. He finds two other cases, or Council found two other cases, which also suggested that you could have a tortious liability, so tortious wrong sufficient to found the defence. but he took the view that they were either criminal in nature or on closer analysis the reasoning couldn't stand. But there needed to be some culpable, dishonest or illicit behaviour. And then he goes on to say at paragraph 28, apart from these decisions, the researchers of council have uncovered no cases excuse me, in the long and much litigated history of the illegality defence in which it has been applied to acts which are neither criminal nor quasi-criminal, but merely tortious or in breach of contract. In my opinion, the question of what constitutes turpitude for the purpose of the defence depends on the legal character of the acts relied on. It means criminal acts and what I have called quasi-criminal acts. This is because only acts in these categories engage the public interest, which is the foundation of the defence. Torts other than those of which dishonesty is an essential element, breaches of contract, statutory and other civil wrongs, offend against interests which are essentially private, not public, and there is no reason in such a case for the law to withhold its ordinary remedies. The public interest is sufficiently served by the availability of a system of corrective justice to regulate the consequences as between the parties affected. And in this case, if and insofar as it can be called quasi-criminal, there's no dishonesty in this tortious act of battery. There's no other culpability. Claimant has established that in the Crown Court.
But can it seriously be suggested that it doesn't engage the public interest if you intend to kill somebody and do kill them intending to do what you do, even though you are not held to be morally culpable or blameworthy for doing it? It's a very different situation, and it's one that Lord Sumption wasn't actually addressing.
I appreciate that. He wasn't addressing it. There is another point of principle that goes on from that, though, that what he is talking about is the need to involve the public interest in order to... the question really is whether it's necessary to serve the public interest by withholding the court's permitting the claimant to come to court, by debarring the claim.
That seems to me to be a very different sort of test from simply looking at whether somebody is morally or criminally responsible for the act complained of, but rather asking whether the quality of the act itself is such as to engage the public interest.
And the only examples that Lord Sumption has given are examples where there is some wrongfulness, something which underlies this statement.
Or moral blameworthiness, as in the case of prostitution.
Yes. So it's an illegal or immoral act, a wrongfulness. And so this is going outside that, and beyond anything that's happened before. And it's our submission that the public interest is sufficiently served in this case by a combination of corrective justice in two ways. The victims have potential claims against the claimant, and the claimant has his, we say, claim against the defendants. And insofar as public safety is concerned...
Sorry, just pausing there. So the victims, you accept, have a claim against the claimant, or their estates in this case. But
Morrison, Marsden and Dunnage and Randall suggest that the victims would have.
yes, you accept that.
Against Mr.
So
Bushman.
insanity isn't a defence.
And insanity wouldn't be a defence as the law currently stands.
Sorry, I just wanted to, I interrupted you, so I just wanted to get that clear. You said public interest is sufficiently served by the corrective claims in between the parties.
And indeed, just to
What was the other point?
the claims from the victims against the claimant and the claimant as against the defendants. And in fact, the victim's claims against the claimant would benefit from the claimant's claim against the defendants, which which seeks an indemnity. In
Well,
respect
so would the claimant, because he'd get off without having to pay any money to the victims. Because if he's right, he gets a full indemnity from the person who let him out. So where's the corrective remedy there? If you get a full indemnity up the line, he ends up not having to pay the damages.
And my lady, that we would say is the just and right result in circumstances where the claimant, the killing should not have taken place and would not have taken place but for the negligent care of this claimant who had no culpability for his action.
So can I just spell this out? I think it's obvious, but I want to make quite sure. So what you say is the claimant can sue the defendants in these cases. One of the forms of relief he will get is an indemnity. The victims or their estates can sue him, and he will be in a position to pay because of the indemnity. Not quite. How would that work as a matter of mechanisms? They sue him. They get. In this particular case, alas, they're dead. The claims of their estates would be very small. But suppose they'd suffered some permanent and expensive injury, they would sue him, recover £1 million damages, compensation. Who would enforce the indemnity against the defendants? Against the people who call against, let's say, the police.
The claimant.
Sorry?
The claimant bringing this claim.
But how would he do that? Would he have an interest in doing it? He'd be, let's suppose that he's still in a mental hospital. He'd just be allowed to be made bankrupt, wouldn't he? Am I being slow?
I suspect it's me being slow. But if he
The victims
yes,
sue and they get compensation,
yes,
an award of compensation. They want to enforce that against him. He has no money of his own, and he is, let us assume, still in, I don't know if it's Broadmoor, but let's say Broadmoor as a shorthand. How do they actually get their money?
it may be.
Well, they've got an award of compensation against him.
Yes.
He hasn't any money.
He has no money.
Yes, so you say that's fine. They'll get the money off the local authority. Just explain to me how. I'm not saying it can't be done. I just want to understand it.
No. All I meant was, if he is in a position to claim an indemnity, if he can bring his claim, and if he's successful in establishing an indemnity, then he himself can obtain that.
I think possibly the answer to my Lord's question is a third-party debtor order, or whatever they now call a garnishee.
Well, that's the sort of answer I wanted. That might well be the answer. I don't know.
I was trying to make a point that the corrective justice can be met as between the parties.
Yes, but I wanted to. I know that was the point you were making. I just want to see how it would work in practice.
I understand that. And it would be wrong to ignore the fact that there's also public safety concerns expressed, and that I understand. But that is managed by the risks of managing the claimant's mental health under the auspices of the Mental Health Act. And there is no public interest here in my submission which requires the court to withhold those ordinary remedies. There is a countervailing public interest in enabling him to hold the authorities to account and for the lessons to be learned from that. At paragraph 29, if I may, staying with les laboratoires, we go on to see Lord Sumption considered, went on to discuss the fact that not all criminal and quasi-criminal acts will amount to a turpitude which is sufficient to raise the defence. And the reasons for that, apart from whether it would be a trivial offence, are illustrative, in my submission, of the need to have culpability, the need to attribute culpability to the claimant. He talks initially at paragraph 29, which is page 570 of the bundle, about the possible offences which are too trivial to engage. And then he says this: in general, however, the exceptional cases are implicit in the rule itself. So he's coming back to.
So sorry, where are you reading from?
Sorry, paragraph 29, which
Yes.
is on page 5.
Okay, no, I've now found it. Just 4 lines up from the bottom. Yep.
In general, the exceptional cases are implicit in the rule itself. It's going back to the immoral or illegal wrongdoing. This applies in particular where the act in question was not in reality the claimant's at all. He goes on, doesn't stop to consider cases of agency, but he might have included examples where, for example, a claimant had only been vicariously liable, or issues as between principals and agents, and those cases which, you'll know better than I, but the necessity of attributing knowledge and culpability to the claimant.
You don't need to attribute knowledge in order to be vicariously liable.
No, and so would be if you were merely vicariously liable, the illegality defence would not attach, would not act to defeat your claim.
Even if it was dishonesty committed in the course of employment.
Yes, as against the employer, it would not defeat the claim. And inherent in this is that the claimant must have had some responsibility from the act. The culpability needs to be attributed to the claimant before the defence can arise. Back in paragraph 29, on the top of page 571, the assumption goes on to consider an exception to the normal rule that a criminal act will spark or enliven the defence by looking at the category of strict liability offences, where the claimant was not privy to facts making his act unlawful. In other words, that he didn't know what he was doing was wrong. So if you look at B at the top of, just above B at 571, in such cases, the fact that liability is strict and that the claimant was not aware of the facts making his conduct unlawful may provide a reason for holding that it is not turpitude at all. It turns again on the presence of or absence of attribution of culpability. And the defendants say, well, this application relates only to strict liability offences. But the claimant is in a much stronger position than a person in a position of a strict liability only offence. He can assert not only that there was no offence, using strict liability, not a criminal offence, but that he has already established that, as is required here, he has already established that he was not privy to the facts or that he did not know what he was doing was wrong. And if you carry on at paragraph 29 of Lord Sumption's speech, page 571 of the bundle, at the bottom of that page, he illustrates this. They're about 3 lines down. The application of the exception for cases of strict liability, about 3 lines down from the top of the bottom paragraph. The application of the exception for cases of strict liability may require a court to determine whether the claimant was in fact privy to the illegality, and to that extent an inquiry into his moral culpability may be necessary before his act can be characterised in law as turpitude. So the claimant's moral culpability may be necessary before his act can be characterised in law as turpitude. This may be a difficult question, but it is not a question of degree. The conclusion will be a finding that the claimant was aware of the illegality or that he was not.
What is the status of these passages? Obviously, are spoken by law assumption, but in a case which not very close to this one, on any view.
I think the defendants introduced the case in order to illustrate that there was a turpitude here.
No, I follow that, but you are now going through it. I understand that, but I'm just saying, well, what do you say the status of all these observations are? They're not necessary for the decision in the case.
As I said at the beginning, from my submission, it's very straightforward. There is clearly established authority that you need to have an immoral or an illegal.
Sorry, can you speak up a little?
So you need to have an immoral or illegal act, broadly speaking. You need a wrong. You haven't got the wrong and the culpability, and so it doesn't arise here. But I'm dealing with the point that the defendants raise, which is, well, there is a subcategory, quasi-criminality. And what I'm submitting is that if you read the judgment of Lord Sumption from paragraphs 23 to 29, where this term was coined of quasi-criminality, it's coined in a specific context.
No,
it's not a context.
Well, and in a case in which the issue simply didn't arise in that case.
Yes.
So anyway, we've looked at it now.
The point is that they wish you to rely on this particular subcategory, which is not anywhere else relied upon. What can they do? They can turn to that, and I said, well, then be careful, because that isn't authority to override all the previous law. That the classic statement is of the rule is relevant.
Yes,
still.
and it's fair to say that the issue that the court was addressing was how far does the doctrine go?
Yes.
But I say it's not a case that is remotely linked to this one on any issues. All right.
Perhaps more importantly, then we come to public policy and the particularly the application by the judge in this case of the trio of considerations in Patel and Mercer. And as above, as I've said more times than you can count, where there's no turpitude, then in my submission the defence is not enlivened, and you don't need to get to the point of applying the Patel and Mercer. The trio of considerations there is not about identifying whether there's a potential turpitude. You still need something there. Another point related is that we know, of course, that Patel and Mercer was not ground zero. And where there is established authority which concerns cases with similar facts, there is no need for an elaborate analysis of the trio of considerations. And the authority for that is Supreme Court in Henderson. And that is at paragraph 77 of the judgment, which is tab 34 and page 962 of the bundle. Lord Hamlin, I'm beginning at paragraph 77, he had just been explaining that the judgment in Patel and Mercer was clearly expected to give guidance generally across civil claims, but he says, thirdly, that does not mean that Patel represents year zero, and that in all future illegality cases it is Patel and only Patel that is to be considered and applied. That would be to disregard the value of precedent built up in various areas of law to address particular factual situations giving rise to the shown that they're not compatible with the approach set out in Patel, in the sense that they cannot stand with the reasoning in Patel, or were wrongly decided in light of that reasoning. And it goes on, and Mr. Warnock took you to this yesterday in the judgment of Your Lordship Lord Justice Underhill and Academia and Shikali. And in that case, in employment law, the touchstone for the availability.
We had this yesterday, did you know?
You did. Mind you, that the purpose of taking you to this is that one might equally say in this case that the touchstone in cases such as this has been recognised as being whether the claimant was guilty of manslaughter or not guilty by reason of insanity. And that was a matter which formed the basis of the reasonings we looked at in Edison in particular. And it might be said that the judge could have stopped there and have not undertaken an elaborate analysis of the trio of considerations in Patel. The judge would have been entitled to find an absence of turpitude or establish principles and have stopped there. But Mr. Justice Garnham didn't do that. He went on to consider Patel and Mercer, and he distills the policies behind the illegality defence as set out there. He distills the test, and he goes on to consider that there is no good policy reason to bar the claim when he's looking at factor A. Without that, there cannot be. He finds that the defence cannot apply, and he moves quickly through C and through B, and countervailing policies, and he doesn't consider it necessary to go on to consider the disproportionality test, part C of Patel and Mercer. And my submission is that that was a reasonable approach, but even if he had applied a more elaborate analysis, he would have come to the same conclusion, and that is the inevitable conclusion, really, of applying those factors to a case such as this. I just remind you for your note that the principles and the test set out in Patel and Mercer were distilled by the judge at paragraph 110 of his judgment, which is at page 156 of the core bundle. And my suspicion is that that is an accurate summary of the relevant paragraphs in Patel and Mercer. Might it help to take you to the judge's summary so that you can see that he applied that correctly? So that is at page 156 of the core bundle. Dismissing, this is at paragraph 110 at the bottom of page 156. Dismissing the appeal, Lords Toulson, Kerr, Hale, Wilson, Hodge, J.J. held that there were two policy reasons for the common law doctrine of illegality as a defence to a civil claim. A person should not be allowed to profit from his own wrongdoing, and the law should be coherent, not self-defeating, and should not condone illegality. Whether allowing a claim would be harmful to the integrity of the legal system depended on whether the purposes of the prohibition that had been transgressed would be enhanced by denying the claim. That's perhaps part A. Whether denying the claim might have an impact on another relevant public policy, the countervailing policies, part B, and whether denying the claim would be a proportionate response to the illegality. Within that framework, a range of factors might be relevant, and it was not helpful to prescribe a definitive list. That said, the courts could not decide cases in an undisciplined way, and a principled and transparent assessment had to be made. Potentially relevant factors included the seriousness of the conduct, its centrality to the conduct, whether it was intentional, and whether there was disparity in the parties' respective culpability. And he reminds himself that punishment for wrongdoing is the responsibility of the criminal courts. The civil courts are generally concerned with determining private rights and obligations, and they should neither undermine the effectiveness of the criminal law nor impose additional penalties disproportionate to the nature and seriousness of any wrongdoing. And that it reflects paragraph 108 if you tell that last. He went on in his judgment to note the application of Patel and Mercer in Henderson and also in Stockholm and Rondona. And at paragraph 122 of the judgment, he summarises the guidance as to its application. I think it's helpful here to look at the judgment of Lord Lloyd Jones in Stockholm, which is at tab 33 of your Bibles, page 896.
Can't tell me which bundle that's in, can you?
So the bundle is 896.
Yes, but which bundle
It's
is
in-
896?
it's second.
Second bundle, thank you.
I'm not sure we have a second division of.
No, I think it's in the.
I think it's in 4. Oh, no,
Double
no,
zero.
it's in 3. Sorry, it's in 3.
Illustrates my point about markers on the back. 33, did you say? Thank you.
Tab 33,
Yep.
paragraph 26, Lord Lloyd Jones. In the application of stages A and B,
So you said, sorry, which paragraph did you say?
paragraph 20.
26. Thank you.
It's from E.
Thank you.
In the application of stages A and B of this trio, a court will be concerned to identify the relevant policy considerations at a relatively high level of generality before considering their application to the situation before the court. In particular, I would not normally expect a court to admit or address evidence on matters such as the effectiveness of the criminal law in particular situations, or the likely social consequences of permitting a claim in specified circumstances. The essential question is whether to allow the claim would damage the integrity of the legal system, and the answer will depend on whether it would be inconsistent with the policies to which the legal system gives effect. The court is not concerned here to evaluate the policies in play, or to carry out a policy-based evaluation of the relevant laws. It is simply seeking to identify the policies to which the law gives effect, which are engaged by the question of whether to allow the claim, to ascertain whether to allow it would be inconsistent with those policies, or where the policies compete, where the overall balance lies. And so if you come to stage A, and you're looking at policies in favour of debarring this case, the first reminder, perhaps to oneself, is to keep the focus of inquiry on the question of coherence and consistency, and to ask whether allowing the claim would be harmful to the integrity of the system. By looking at how the legal system in the UK gives effect, or in England and Wales, gives effect to the policies concerning homicides by mentally disordered people. And that's why I come back to the same thing, where you start with the statutes. And responsibility manslaughter defence is partial, and that manslaughter responsibility remains. And the Trial of Lunatics Act, as amended, mandates the finding of not guilty for an insane person. So that Parliament gives effect to the legal policy of the country by distinguishing between the criminal conviction of manslaughter and an acquittal for insanity. And it is not, bearing in mind the guidance from Lord Lloyd-Jones, it's not for us to be going behind and making arguments as to whether insanity is an adequate test, or looking at the questions behind that. But what is the test? We've identified them, as in the Homicide Act, as in the Trial of Lunatics Act, and the McNaughton rules. And when in Henderson, the claimant in effect argued that the criminal test for insanity was discredited, describe it as discredited, and that the civil law should provide their own test and not apply this line to the question of the application of the illegality defence. The answer from the court was consistency and coherence demand civil law respects the criminal law's distinction. In effect, that was their answer. You should not go behind it. You should not develop a different test, because if you do so, more inconsistency will follow. And that is, for your note, paragraph 108, which we looked at earlier in Henderson, which is at page 697 of Electronic Ramble. And in this case, the defendants are effectively trying the same from the other side of the same fence, asking you not to respect this fundamental distinction that's recognised in the criminal law. It's unclear what test they propose, but it is suggested that it is a cigarette paper between diminished responsibility, manslaughter, and insanity for the purposes of this illegality defence. My suspicion is that that approach needs to be treated in the same manner as Henderson treated the argument before it. It should be rejected, and the bright line should remain as it was identified in Clunis and in Henderson, to be dependent on the legal characters of the acts and the distinction between manslaughter and not guilty.
How would you do that in a case where there hadn't been a criminal conviction? I don't think you're suggesting that this only arises in a case where there's a criminal conviction. You could have exceptional cases where the illegality rule was invoked, even where it was said a criminal offence had been committed.
Yes.
Perhaps had been committed abroad, or for some other peculiar reason it hadn't been prosecuted, or it was a case for quasi-criminality,
Yes.
so that there wasn't a criminal offence. But insanity was still being argued as the defence. How would that work?
In an American case, that effectively was what happened, because he hadn't yet been tried for the criminal case, and it was said that the defence of insanity would be raised, and the answer was, well, you haven't yet. That factual inquiry needs to be made. We need to determine whether or not there was insanity, or the defence is not enlivened. I suppose you'd say, well, the defence isn't enlivened, where there is, where the claimant is able to satisfy the court that he didn't know what he was doing was wrong. It would be for the claimant to satisfy the court.
Thank you.
And it's right to say this in terms of the coherence and consistency principle in a diminished responsibility manslaughter case, as has been established, permitting a civil claim for the consequences of that conviction and sentence for manslaughter would mean the law is giving with one hand what it took away with the other. Whereas in an insanity case, debarring a civil claim, where the claimant was acquitted in the court, would mean that the civil courts are in effect adding punishment where the criminal court refused to do so. And it would be incoherent to permit a claim in these circumstances, in the obverse of the diminished responsibility of manslaughter. And my lady asked earlier about whether
Yes, I mean,
what about the effect of law for these
it's not really a punishment, is it? It's just saying that when looked at, not saying that the claimant doesn't have a legitimate cause of action, because otherwise the illegality doctrine is neither here nor there, but it's saying that public policy reasons, it's not a claim you can pursue for compensation. It's not a punishment as such. It's just one of those, the application of the doctrine to prevent a claim for compensation for loss.
And to prevent, if you like, the ability of the claimant to vindicate those rights that he has, and to ask the courts to hold those who caused this to happen to his life to occur, and it's so negligent.
Yes, I find it difficult to see that. Let's assume for a moment in relation to a claimant who is seriously unwell and has satisfies the court in relation to a diminished responsibility defence that they were seriously unwell at the time they committed the offence, so their responsibility is absolutely the lowest end of the scale. It might be said, well, and they are the ones that they get a double blow, as it were, because they're convicted, and they are then deprived of an opportunity to do anything about it. So, I mean, I'm not sure it's a point which adds anything to either argument as a point of principle.
I think it was something that it felt harsh to do from the judicial perspective, to decline a remedy to Mrs. Henderson in those circumstances. But the distinction between manslaughter and being not guilty by reason of insanity was different in kind, not just in degree. And it couldn't be said that this fell outside the illegality doctrine. But in this case, it would be extending that doctrine to a situation where it has been established in law that there was no legal or moral wrong. And that is somewhere where the courts haven't gone before. So it's an extension of the defence. We say in circumstances where it is neither just nor necessary to do so. That criminal distinction has been recognised, as you're more than aware, in the cases we've discussed. One of the points made yesterday by my learned friend was that the coherence in civil law would be, well, they submit, it would introduce incoherence in the civil law to permit the claimant to bring his claim on grounds of that he lacks responsibility, because he would have the tortious responsibility to the victims in a civil claim against him. And this is the Morrison, Marsden, and Dunnage and Randall point. We say that this was a false equivalence, and the judge was right to reject it. The defendant's argument is it is incoherent for tort to regard Mr. Lewis-Ranwell as responsible for his actions on one hand, whilst absolving him of responsibility on the other. But that needs unpacking a little. What does tort regard him as responsible for? It regards him, I should say potentially, but as liable to compensate his victim in damages for actions which fell below a tortious standard of care. And the standard of that tortious standard of care is an objective standard. It's by reference to the reasonable man.
Yes, can we just be clear about this?
Yes.
That's true about negligence. I think you've also made the same concession about trespass the person.
Yes. Yes.
which isn't as such a standard of a reasonable man. Your point may be just the same, but it requires some clear thinking here. So we're not only dealing with negligence.
Just going back to Dunnage and Randall and Morris and Marsden in my mind, but I think that is.
I can't remember what the cause of action in Dunnage was. That was, I think, negligence, but in Morris and Marsden it wasn't, was it?
Liability as well.
It was trespass in Morris and Marsden.
Yes.
Trespass in Morris and Marsden, but occupiers liability, I think, was also brought in.
Sorry, can you speak up?
Occupiers liability was also involved in the Dunnage and Randall case. But thank you. Trespass in Morris and Marsden.
Trespass in person.
To the person. But the concept of insanity is given no weight at all in the assessment of his tortious liability in those cases. And
Why is that? What's the policy background for that being the law?
the policy background for that is that what tort law is concerned with doing is, in those circumstances, is distributing the risk between the individuals where the risk lies, and it's not concerned with punishment.
Couldn't that be the same? Shouldn't the same point be said to apply here? It's a question of who bears the risk of the classic situation here of two victims: man who's a victim of mental illness, which he can do nothing about. I know there's some factual questions about that, but let's assume for the moment that's the case. And a person who is killed or seriously injured by that person without any provocation. So two victims. Isn't it equally a question of who bears the risk between those two innocent people of the severe injury which the injured person has suffered? Tort law obviously says, well, I know victim one, the insane person, is morally innocent, but the fact remains he or she did it. And the other person suffered it. And so although they are both at some level innocent, it's right that the person who did it should pay compensation.
Yes,
Now, isn't that exactly the same question in reverse as we're concerned with here?
No, in my submission, because here the claimant is claiming as against defendants who permitted this to happen. They haven't been. They're being judged.
No, that's a fair point. But does that make all the difference?
Yes, my submission. So the criminal law is designed to do the punishing, if you like. The civil law isn't in the tortious distribution of risk. When he is facing a claim as against him, with making no comment on his moral culpability, tort law says you need to compensate the victim.
I think in one of the authorities, and I forget which one it is, but one that you showed us, there is an explanation of the illegality principle as being concerned with distribution of risk and leaving the risk to lie where it falls.
I think that's Lord Mansfield, in fact.
Yeah.
He's saying that, as I understand it, so that the defendants in this case would have a windfall defence if they succeed in striking out on this basis. But it's a point of law that if there is an illegality defence, that the court is obliged to take, and the risks will just fall where they do. I don't think that answers the same question of whether or not the defence can be engaged. Whether there's been any liability. There are circumstances in tort law where the question of fault and culpability and insanity does arise, and that I think is the contributory negligence point which you're not earlier.
Yes, but anyway, No, I'm just thinking about just internalizing the answer you gave me previously, which is that these two situations are fundamentally different, because in the question of primary tort liability, the person who gets the benefit, as it were, of the claim is the actual victim, whereas in this case, the person who gets the benefit of the defence of illegality is someone who hasn't suffered anything. Okay. Thank you. It's helpful. Sorry, do go on, but you said about contributing negligence.
Your Lordship had asked how contributing negligence treats insanity.
Yes.
And the answer to that is that it is taken into account because contributing negligence does concern itself with questions of culpability. And the two cases which are not in the authorities bundle, but we can have printed. There was a difficulty coming in at lunchtime, I think, because of an alarm, but they can be handed up. Looks like we've got them all now.
What are the cases? I suspect we know them.
So briefly, Reeves and the Commissioner of Police for Metropolis was Metropolis. We had got the Court of Appeal Authority in the fund, but not the House of Lords Authority, and we have a copy of that. This was a claim, to illustrate the principle, where by the estate of somebody who had killed himself. It was a claim against the police, who was said to have prevented the death. The trial judge found that the deceased was not acting under any disability or compulsion when he chose to take his own life, but had he been insane, if you like, or under such compulsion at the time, then he would have been in the same situation as Mr. Kirkham was in the previous suicide case, the Kirkham case. In the Kirkham case, there was contributing negligence alleged, and that was that there was none. Zero deduction to that because he was insane. In this case, of Reeves, where the deceased had chosen to take his own life when not labouring under the same insanity, there was a 50% reduction in his damages.
So what you're saying is clear from Kirkham, which we've either got or certainly referred to in the cases we have got, is simply that if you are insane, contributing negligence doesn't apply. Is that right?
Yes. There is a very recent case where Martin Spencer J was sitting, called Spearman. It's not that recent, 2017. Spearman and the Royal United Hospital of Bath. And we have got copies of that, or can get copies of that if we haven't. Where there was some consideration of this issue, and I can, in short, the claimant was diabetic. He suffered a hypoglycemic attack. He was admitted to hospital, and he left the emergency department, climbed onto the roof, and jumped off, suffering injury. And this was judgment of the trial of his claim for negligence and occupiers' liability. And the defendant alleged contributing negligence as against the claimant. And Martin Spencer J addressed that at paragraph 72 to 74. I'm afraid I haven't got it in front of me now, but a reduction was rejected. And here is the part I do have it. At paragraph 74, in my judgment, contributing negligence is negative by the claimant's state of mind, as I have found it to be, whether as a result of the ongoing effects of the hypoglycemic attack or the effects of the pre-existing brain injury or a combination of the two. The claimant did not appreciate the danger he was in, timing the offence, and just as a young child is not guilty of contributing negligence in running out into a road, when the child is so young as not to appreciate the danger of so doing.
Well, speaking for myself, I can't obviously speak for my ladies, but as the person who raised it, that's enough for me to go on. Obviously,
Just out of interest, was Dunwich and Randall cited in that case?
Without a list.
Oh, sorry.
I just turned my back. Johnson finding out. So
It does seem to me, on the face of it, to be slightly inconsistent, at least with Lord Justice Foss's analysis in Dunwich and Randall, which is why I asked the question. I have in mind, in particular, the passages, paragraphs 130 to 133, page 631. That's not about contributory negligence, of course, it's about negligence simple, but one would have thought that the approach should be consistent.
In contributory negligence, culpability is a part of it, whereas it isn't in distribution. As between, if the distribution is in contributory negligence is where two people are at fault. In permitting Lewis-Ranwell to claim, it doesn't absolve him of responsibility to pay any compensation he owes, but it does pay heed to the criminal court's finding of no criminal or moral culpability, responsibility, and to pays attention to the need to provide civil remedies for civil wrongs.
Sorry, what doesn't absolve him of the...
The fact that permitting him to bring a claim wouldn't absolve him of his responsibility to pay tortious damages to another.
I thought you were asking for an indemnity. An indemnity operates to do that, doesn't it? It absolves him on the basis he shouldn't, as a matter of principle, be liable to pay. However one characterises it. Well, we've covered this ground already.
It doesn't change his liability to others, but it does.
I think you said it doesn't absolve. Yeah, all right.
It distributes the risk.
It doesn't absolve him of his liability, but it does absolve him of the liability to pay anything as a consequence of his liability.
It may fund that. Yes. Other policies to consider under stage A of Paterno in this case.
Sorry, just before you leave contributory negligence, having said what you've told me satisfies, have you actually got those authorities here? What you've got? Reeves went to the House of Lords, you say?
It did. This is Spearman.
I'm not particularly, Spearman. I'm not particularly asking to be sent now, unless you want to make further submissions. But I'd just like to have it at some point.
Yes.
Yeah, thank you. And just before we leave this, there's another police suicide case, isn't there, called
Core.
which we haven't got. That doesn't deal with this point, is that right?
It's discussed in Dunwich and Randall, certainly, and excuse me. It's raised in argument in core, but not dealt with in the judgment by Junior tells me.
Sorry, thank you.
I was just going on to consider another policy which the defendants ask you to weigh in the balance under stage A of Patel, and that is the question of deterrence. It is submitted on behalf of the defendants that barring this claim would act as a deterrent for killing. and that the judge paid insufficient attention to the reasoning in Henderson about that. Can I take you to the passage in Henderson? It's at paragraphs, so it's tab 34, page 971, paragraphs 1 to 9. The prohibition transgressed in Henderson was, of course, there was an unlawful killing or manslaughter. And at paragraph 129, Lord Hampden says this: in relation to the underlying purpose of the prohibition transgressed, an important purpose is to deter unlawful killing, thereby providing protection to the public. As far as the public is concerned, there could be no important right to be protected than the right to life. It is clearly in the public interest that everything possible is done to enhance protection of that fundamental right. There is also public interest in the public condemnation of unlawful killing and the punishment of those who behave in that way. Just pausing there to note that it shows how the word unlawful killing is used here. It's in connection with punishment, and of course that is absent in a case such as this. But the court recognised paragraph 130, on behalf of the appellant, Mrs. Henderson, it was submitted that it's absurd to suppose that a person suffering from diminished responsibility will be deterred from killing by the prospect of not being able to recover compensation. Indeed, more generally, it is submitted that a person who is not deterred by criminal sanction is unlikely to be deterred by being deprived of a right to compensation. And the court held there is force in these points, but the question should not be considered solely at the granular level of diminished responsibility manslaughter cases. Looking at the matter more broadly, there may well be some deterrent effect in a clear rule that unlawful killing never pays, if any such effect is important given the fundamental implications of the right to life. To have such a rule also supports the public interest in the public condemnation and due punishment. And the way in which the judge dealt with that, it was said by the defendants in the court below that the judge had fallen into error in not looking at things on the granular, beyond the granular level. And in this case, the judge said in its paragraph 139 of his judgment, which is at page 164 of your bundle, the judge said, in my judgment, the prohibition being transgressed is the prohibition on the taking of life. That prohibition is not enhanced by preventing a claim in the present circumstances, because the claim flows from the action of someone who is insane and is not amenable to the rationale of the prohibition. It is suggested that there is an obvious deterrent effect in having a clear rule that killing a person never results in compensation. I see no such deterrent. The conduct of a person in respect of whom insanity is proven is unlikely in the extreme to be affected by such a principle. And one can understand how the same comments might have applied to Mrs. Henderson, for example, but the Supreme Court said, nevertheless, you need to look more broadly about the benefits of having a rule that manslaughter cases, that unlawful killing never pays. And he was talking about looking more broadly than diminished responsibility manslaughter cases. And my submission is that the distinction between the insanity defence and the manslaughter defence justify the different treatment here, because there is good policy reason for that view taken by the Supreme Court in Henderson, that such a clear rule might well be effective when you look at manslaughter cases more broadly than diminished responsibility. For example, a clear rule that gross negligence manslaughter never pays might affect the way in which state bodies organise their services to enhance the right to life. But that kind of distinction between different manslaughter cases does not apply here, and that difference does justify the distinction. But just as importantly, a part of the justification for the application of that policy in Henderson was that there was an argument for demonstrating public interest in condemning and punishing a person in the situation of Mrs. Henderson and others. So in punishing those who were responsible for manslaughter. And there is no such public interest submitted in condemning and punishing a person in an insanity case where absence of any responsibility has been proven.
Do you have anything to say about what's said in paragraph 133, in particular at the end of it? Because I think one of the things you said in relation to this case is that it's important that what happened to the Mr. Lewis-Ranwell in this case is, and the way he was treated or not treated is dealt with, and he's got the opportunity to deal with it. But one sees what's said at the end of 133. Just looking at, if you're looking at a balance of public policy issue matters, then is that relevant?
Yes, it is, my lady, and I was going to come on to look at those countervailing policies in a moment, but to say, yes, what is suggested here is that it doesn't seem likely that NHS staff or organisations need any encouragement to try to do their best to stop patients killing people. And I have no doubt that being a police officer working in mental health or a liaison and diversion mental health professional or a person who is on duty late in the social, I have no doubt that there are a number of difficulties attendant upon those jobs. But in this case, there are distinctions. The claimant was in the custody of the police station in a particularly vulnerable situation. And you will have seen from the particulars of claim the sheer number of shortfalls in the care provided to him. And that was in circumstances where there was ample information in his past medical records available to some, not all of those defendants. There was ample to flag up the risks that were there. There were 3 telephone calls from his mother, and one, the note that everybody sees is that everybody had access to, is that there would be grave danger if he was released. There was a failure to share information despite requests between the parties, and so on and so forth. And this is in a police station. There is CCTV footage of what happened, and the question of whether, as a broad general rule, people need to draw a distinction like that, because the illegality defence, it's not likely that staff or organisations need any encouragement. My submission is that wouldn't apply. Doesn't appear to be the case on the basis of the facts of this, and certainly of some other cases. And what does encourage change is a clear delineation of, in a case such as this, if there's no civil litigation, there can be internal reports, there can be commissioned reports, but what isn't at present is an ability for full disclosure as between parties. There isn't an ability to test the evidence forensically, and so on and so forth. And so the lessons to be learned are lost. That is an important countervailing policy. I'm conscious of the time, and I think I addressed briefly in response to Justice Underhill's question earlier the points in relation to public confidence and the warnings about being circumspect.
Yes, and don't forget the issue of paying compensation for lawful detention.
Yes.
Which is an issue that you don't have to deal with it now, but
No.
just go on to your.
It's a simple point that lawful detention under, for example, Section 3 of the Mental Health Act, or Section 2 of the Mental Health Act, or the effective lawful detention that happens to somebody under a deprivation of liberty safeguard. These are factors which come into play in the ordinary run of personal injury claims. A person with a brain injury or an illness that has been caused or exacerbated by a tort will often include in their claims a claim for damages for the fact that they now are having periods of time in lawful detention or deprived of their liberty. And that it doesn't seem to me in itself a reason of public policy. There will be issues of causation in this case as to how long he would have remained a patient if he had been diverted on that day. But the claimant's case has pleaded and taken on that basis that he would have had a period of 6 months.
But do those cases involve an order by the court or a disposal by the court that there should be detention, or is it simply detention because of the decision made by the admitting physicians?
Well, and by the admitting physicians or under the Act.
Yes.
Yes.
So here, this is the operation of a different route for detention, which is by reason of the verdict of the court,
yes,
and then a disposal
based
by
on the mental health observations and satisfying the requirements of Section 37 of the Mental Health Act, that he has a disorder which it's appropriate for him to receive treatment and there is treatment available. It's a mechanism by which the court can ensure they've got the psychiatrist in court, they can hear the evidence, and an order is made for him to go on. But it doesn't, in and of itself, create a new creature. It's effectively, I don't see the bar in that from being able to receive compensation for the fact that you're lawfully detained, just as you would if you were lawfully detained as a consequence not of that. Excuse me. Yes. Johnson reminds me of deprivation of liberty, of course, might also be authorised by the court. I'm conscious of the time and the timetable which we gave, and I think I'm perhaps running out of that somewhat, but my submissions in relation to the public policy defences are set out in the skeleton argument, and perhaps I could refer you to those. In short, we say in relation to stage B of this that having found no good policy, a reason to debar the claim, the judge was right not to consider the policy reasons against doing so in detail. But had he done so, we would have asked him to reconsider that he should have accepted the submissions, which he summarises at pages 60 to 69 of the judgment. And I think which have been running through the submissions I've been making all morning, that to debar the claim is consistent with the finding of the criminal court would extend significantly, one might say, turn on its head the defence of illegality with unknown consequences across the civil law. If culpability, either moral or lawful, needs to be established for the ex boundaries of it. It would disproportionately affect the most severely mentally ill people in our society. It would run counter to the public interest in protecting the rights of the mentally ill, most mentally ill people in police custody. And as the House of Lords recognised in Chester and Afshar, the duties owed become hollow if you strip them of all practical force and deprive a person of their right to seek compensation or enforce their care. And it would be doing so in circumstances where the very thing that the defendants were engaged to do was to take steps to prevent this from occurring. And the turpitude that the defendants seek to identify, the acts, were the very thing which we say, as a matter of fact and law, were caused by them. And it would be an affront to the public conscience that there is no mechanism through which the courts can investigate and hold to account the public authorities for their failings.
This is a compensation claim. You can't justify. You can justify it because he ought to have compensation for the wrong he suffered. You can't do it on the basis that it should be some sort of public investigation into failures of care. That's done by completely different mechanisms.
Well, there is authority to the effect that it is a matter for the there is authority to the effect that a claimant who seeks to pursue a claim even without compensation to vindicate his right, that the tort law does serve that,
the vindication of his rights is the obtaining of compensation for the civil wrong.
It is.
It's not a full-scale public inquiry into
No, not seeking a public
for the benefit of others, as it were.
No, but it also brings with it, what the civil litigation brings with it is a matter of wherever you reach the end of that, it brings with it the ability to compel witnesses, to compel disclosure of documents, to get to the bottom of it. And that is an important...
But it's obviously important. I'm not quite sure what you're saying. I've got your main point, which is obviously a powerful point. If you're saying instead of that irrespective of any right to compensation, it would be wrong to strike this out so that there could be a trial in which the omissions by the police or the health authority, various bodies involved, could be investigated. That's what I'm questioning. But if you're not saying that, what are you saying?
And so, when one looks at the countervailing policies, what are the policies against debarring this? If you debar it, there will not be that civil claim, that process, which is an important one.
Well, it's important in order at least you get compensation. It's not important in order that there should be an inquiry into how mentally ill people looked after in North Devon. I quite accept that the jury obviously thought that was very important, but that's not what you bring a claim like this for.
Well, with respect, it can be a part of it. There is at the back of the bundle helpful sections in relation to that in Clark and Lindsell. But about
sorry, can you speak
up?
up?
In Clark and Lindsell, for example, and you look at even chapter 1, where you're looking at the role tort plays in vindicating rights as well as in corrective justice. It's not my main point, but it is a point that if you deprive, if you outlaw a claimant, despite the circumstances of this case, and prevent them coming to court, you prevent that process.
That would be true in any case in which somebody was found guilty by reason of diminished responsibility. The concomitant would be that they wouldn't get the compensation which they would otherwise be entitled to, and there wouldn't be a full inquiry into the reasons that gave rise to them being let loose to commit the criminal offence.
That is right, and that may be a loss. And when weighing in the balance the policies for and against deferring a claim, that may be something that weighs heavily, but ultimately, because there was a serious criminal offence in those cases, and there was moral culpability, those types of points were outweighed.
The only difference is moral culpability. I think ultimately what you're saying is that it's the absence of criminal blame that makes all the difference as to where the bright line should be drawn.
Yes, criminal blame, and also the basis of the defence being not knowing what was doing was wrong. So the moral culpability. May I just very briefly address you in relation to stage C and proportionality,
Yes.
because I'm conscious I'm overrunning my time, but the judge didn't go on to consider proportionality because of the authorities Henderson and Stoffel and Grondona demonstrating that it's not necessary, it's not necessary to consider the question of whether it is disproportionate to apply the defence, unless the judge of the court has already found that it's about to apply it, that you've passed, as it were, through the control mechanisms at gate A and B. It's the last hurdle. And so it was reasonable of the judge to stop short of doing that. But if you were to get here, and if he was to have got here, it is important to take account of the fact that Patel and Mirza requires you to look, and Stoffel and Grondona emphasises, this is the time when you look at the detail of the case before you. And I recognise it's a very long particulars of claim, and it's long because it was sustained in cumulative failings, we say, by 4 different defendants over 2 days. But it was also in part anticipating the fact that this may come before the court as a preliminary issue, which had been canvassed in the pre-action letters. And the only information that is before you on which you can judge an important aspect of proportionality, it is the information in that. And that is the question of relative culpability. And I would ask you...
Can I just say, I want to be clear about this, something my lady raised yesterday. If it all turned on proportionality, then it would be very difficult, wouldn't it, to deal with as a strikeout?
well,
Because you're saying, well, all the material you've got to decide proportionality is what the claimant says, but we don't know what the defendants say.
Well, the defendants chose to bring this matter before the court now, and so on a strikeout application, you are obliged to take as read the particulars of claim and to treat that as the evidence in the case. The defendants say, even taken at its highest, this is an illegality defence. Should I sit down in order to allow my opponents to...
Well, I think that your time on the schedule that was agreed between the parties, you were timed to finish at 3:30.
I thought it was 3:50.
I think it was 3:30.
I've got one question, if I may.
Yes.
Just one question from Ms. Plowden. I don't think an area you have addressed is one that I'm not sure Mr. Warnock said a great deal about in his oral submissions, but is in his skeleton argument, which is the point about distributive justice in the specific context of this being a public or these being public authorities. Is there anything you want to say about that? Or maybe you're content to rest on what you said in your skeleton, which you just need to show me the paragraph.
So I have referred to it in the... Sorry. Yes, the point I was making was that the defendants are reaching for this wide distributive justice point by analogy with McFarlane and Tayside and White and the Chief Constable of South Yorkshire. And
Sorry, you were saying it's a point you made this morning, I've just missed it, or?
no, the point that I made, I think it was skeleton.
Yes, I was.
Public confidence rule is at page 19, and then it goes on paragraph 55.
Yes, I see. Yes, well, maybe that's all you need to say, but I just, that will be an element which we will have to consider, not necessarily saying it's the centre of the case, and that you have an answer to it there. Is that?
I have an answer to that, and I might add in the real expense to the public purse in this case has been in allowing the claimant to leave the police station without reference to the Mental Health Act assessment, we say, and that is the cost now being incurred by the system, to be said in any case of clinical negligence or claim against a public authority. Of course, one wishes to safeguard the public purse where appropriate, but equally, where there is a good civil law claim because the public authority has failed in respect of its duties towards you, particularly in such a serious case with, to be honest, relatively modest damage, because we're not talking about the physical injuries of moments inadvertence in an obstetric theatre, leads to a very much larger claim for the NHS to meet than something like this, and that it does not come back in to weigh very heavily against the claim unless you have the turpitude, the illegality, and a very good reason indeed to prevent the claimant going to the court and the defendants from relying on the normal control mechanisms inherent in any negligence claim. Excuse me, next. Mr. Johnson reminds me that one of the academic papers provided by my learned friend Miss Ailing yesterday, Mr. Goodcombe, it is called Mental Abnormality, Personal Responsibility and Tort Liability, and the author is Jules L. Coleman, I think. And Mr. Johnson says, could you mark these to have a look at part 4, because it deals with compensation, fault and mental abnormality in a way which we hope will answer some of the questions raised.
Thank you very much. Thank you. Thank you. Yes, Mr. Warnock, are you replying?
My lady, just on a few points. Sorry. I'll try my best.
I think you've caught the cough from next door.
I think I may have. My lady, as to the issue as to whether the criminal law would regard this killing as unlawful, may I remind the court of the definition of murder, and we've brought along Archbold should the court want it. It's not been defined by statute, but it's recognised by common law that the offence of murder is committed where a person of sound mind and discretion unlawfully kills any reasonable creature with intent to kill or cause grievous bodily harm. So the answer is actually in the definition. One of the elements is that the person is not insane. But the other element is that there is an unlawful killing. It's a separate part of the definition. Would it help if I handed it up? Thank you very much.
Well, that's being handed up. You can carry on.
And secondly, Archbold helpfully at 19.3 summarises what is meant by unlawfully. And that means without legal justification or excuse, e.g. self-defence or bona fide surgical treatment. So the New South Wales Court of Appeal were entirely correct in Hunter and Presland to say that although the claimant in that case had been acquitted on the basis of insanity, there was nonetheless an unlawful killing. That's entirely in accordance with the recognised definition of murder. The second point I wanted to take the court to was my learned friend took the court to the judgment of Lord Justice Beldam in Clunas, and that's at tab 17, page 291 of the electronic bundle. And it's, my learned friend took you on page 291 to letter E, the restriction of the operation of the policy to cases in which the person seeking redress must be presumed to have known that he was doing an unlawful act, as being confirmed in Burrows and Rhodes. Interestingly, if one looks at the actual citation from that case, which is down the page at letter G from the judgment of Mr. Justice Kennedy, he said, "It has, I think, long been settled law that if an act is manifestly unlawful or the doer of it knows it to be unlawful." In other words, although Lord Justice Beldam puts it as requiring knowledge, in fact, the source he cites for that proposition has two categories: a manifestly unlawful act, or the doer of it knows it to be unlawful. And as we have submitted, we submit that the killings here were manifestly an illegal or unlawful act. My lady, my next point on reply relates to consistency. And much was made about paragraph 108 of Lord Hamblin's judgment in Henderson, where he talked about introducing inconsistencies between the civil and the criminal law. The position we put forward, we respectfully submit, is entirely consistent between tort and crime. And can I remind you, or can I take you back to the Attorney General's reference at tab 21, page 452. Tab 21, page 452, the judgment of Lord Justice Judge, who said that to return the verdict of not guilty by reason of insanity, and I'm now looking at passage E, which I don't think either side of the court has taken to you yet. The answer to the question posed by the Attorney General is that when determining whether the defendant did the act or made the omission charged for the purposes of the Trial of Lunatics Act 1883, and assuming insanity, the Crown is required to prove the ingredients which constitute the actus reus of the crime. Although different language is used to describe this concept, for present purposes we respectfully adopt the suggestion in Smith and Hogan criminal law that it must be shown that the defendant has caused a certain event or that responsibility is to be attributed to him for the existence of a certain state of affairs, which is forbidden by the criminal law. That formulation actually chimes with the formulation of Lord Justice Voss in Dunnage at paragraphs, my Lady Justice Andrews referred to, paragraphs 130 to 132. And they are at tab 27, page 630 of the bundle. Tab 27, at the very bottom of page 630, his lordship at paragraph 130 referred to Rafferty LJ's formidable analysis of the authorities and the fact that none of them were binding on them. But he said, it seems to me a line must be drawn. The line should be simple, easily understood and grounded in legal principle. I've already sought to set out some of the parameters, just one remains, namely, is there some principle that requires the law to excuse from liability in negligence a defendant who fails to meet the normal standard of care, partly because of a medical problem. In my judgment, there is and should be no such principle. The courts have consistently and correctly rejected the notion that the standard of care should be adjusted to take account of personal characteristics of the defendant. The single exception in respect of the liability of children should not, I think, be extended. People with physical and mental health problems should not properly be regarded as analogous to children, even if some commonly and inappropriately speak of adults with mental problems as having a mental age of 5. In my judgment, only defendants whose attack or medical incapacity has the effect of entirely eliminating any fault or responsibility for the injury can be excused. It is only defendants in that category that have not actually broken their undoubted duty of care. The actions of a defendant who is merely impaired by medical problems, whether physical or mental, cannot escape liability if he causes injury by failing to exercise reasonable care. What then does it mean to say that a medical condition entirely eliminates any fault or responsibility for the injury? It simply means that the defendant himself did nothing to cause the injury. Leading counsel for the First Defendant gave the example of a person whose arm is holding a knife and who is overcome by another forcing him to stab a victim. The person holding the knife cannot have broken his duty of care because he did nothing himself. In my judgment, however, at all intermediate stages where the defendant does something himself, he risks being liable for failing to meet the standards of the reasonable man. This approach avoids the need for medical witnesses to become engaged with difficult and undefined terms such as volition, will, free choice, consciousness, personal autonomy, and the like. It is only if the defendant can properly be said to have done nothing himself to cause the injury that he escapes liability. This approach is not directly adopted in any of the authorities, but reflects in large measure, I think, the conceptual analysis favoured by at least 3 of the justices in Core and IBC Vehicles Limited. See Per Lord Scott, Lord Mance, and Lord Newberger, who put the matter in terms of asking whether the deceased had no real fault for his suicide.
That virtually confines it in tort to cases of automatism.
He does, which is accords, I think, probably with how the Weetabix case was interpreted. I've had a look on Westlaw this afternoon while submissions were being made to see if this case was referred to or not to Mr. Justice Martin Spencer in Spearman. Unfortunately, Mr. Justice Martin Spencer's judgment isn't in any of the official reports. All I can say is that in the Westlaw summary of cases mentioned are cited. Dunnage and Randall isn't mentioned, but of course that's not to say that it may have been mentioned, and
I
simply
did a
because
similar search, not for that particular point, but I searched Dunnage and Randall last night. It had very little judicial comment at all.
yes,
And none, I think, as far as Westlaw is concerned.
I hadn't myself checked that.
Anyway.
But it's simply because we don't because Spearman isn't in an official report. I suppose we simply don't know.
Generally, it's a case of first instance.
Yes,
And this is a case of a court of appeal.
yes, of course. Yes. Then, in relation to proportionality, can I just remind the court that we've dealt with this? So the Fourth Defendant, certainly, the other defendants will have dealt with it elsewhere, but we dealt with it at paragraph 34. And actually, the factors which Lord Hamblin identified as being relevant in Henderson, we respectfully submit are just as relevant here. In particular, you will recall factors include centrality. Well, clearly the killings here are central. Relative fault, you must proceed on the basis that the defendants have been negligent. But the other side of the coin of that is that because the mens rea was present, these were intentional killings, as was the case in Henderson. And the other factor is seriousness of the conduct. Well, clearly we are dealing with the most serious conduct possible, which is the loss of life, the taking of life. So we submit that actually when one analyses the case by comparison with Henderson, the same result should clearly be reached, and we do not need a trial for that. If your ladyships, my lord, are against us on that, but with us and everything else, and there has to be a trial on it, so be it, but we respectfully submit that actually this court can form the assessment of proportionality, as indeed the Supreme Court did in Henderson. My ladies, my lord, those were the only submissions I wanted to make in reply. Subject to anything else you wanted to ask me.
Well, sorry, I do actually have one question, if I may. I think I know the answer to this, but I think I should put it to you. In this case, the breaches of duty or the torts alleged against your clients, defendants, are all negligence. They're effectively omission, want of proper, well, they're largely omissions, shall we say.
Yes.
But I think your approach would have to be the same. Suppose the doctors in this case, or in to be a slightly different set of circumstances, had in fact caused the insanity by the administration of inappropriate medication. Imagine that. Not very likely, but we know it does sometimes happen. Given the wrong drugs and people have a psychotic episode. If you're right, and then the person suffering from that episode goes out and kills somebody, even in those circumstances, which are rather more extreme, there would be a defence of illegality. Would you accept that?
If we're talking about negligence, yes, I would accept that. And the reason I accept that is because actually we see that distinction in two of the cases we've been considering. In Grey and Thames trains, the defendants actually caused the psychiatric injury because they caused, the claimant was completely well before the Ladbroke Grove train crash. Whereas Henderson involved a case more like ours, where the defendants didn't actually cause the underlying condition, but were said to have failed to deal with the consequences of it. So I think the answer to my lord has to be on the authorities. The answer would be the same in both cases.
Thank you.
Obviously, it would be indifferent if it was an intentional injection caused to.
Well, that might be different, yes. Well, might be different.
Yes, we're saying.
I adopt those submissions. I've just got a couple of very brief points to make. Firstly, just as a matter of practicality, Mr. Goodcamp and I looked last night, pursuant to your question, my lord, about academic material in Henderson. We looked to see if there was anything that we felt was relevant that we should draw to your attention, and we've both independently and together come to the view there isn't.
I can't force you to refer us to anything, but they did look like some rather tantalising recent publications.
Well, we'd be glad to give it to you.
No, we can find that if I think the right way round is that if you don't think they're relevant, we won't.
No.
I wouldn't ask for them, as my lady does, but I don't promise not to look at them myself just in case.
No. And we would like to take the opportunity just to look overnight to check whether there's anything on the question of insanity and contributory negligence which you think it would be helpful for you to see. And I have it in mind that it might just be useful to look at what Clark. I know you'll have access to Clark and Lindsley yourself, but
Yes,
we will.
well, I think in a case like this, which raises a number of issues, it may be the court would wish to refer to other authorities. But if it does, then certainly nothing will be put in the judgment before the parties have an opportunity to make submissions about it, which would be done in writing. I think that's probably the most sensible way to deal with it.
So you don't need us to send you anything, is that?
Well, if you wish to.
I will just do a check overnight with Mr. Goodcamp to see whether there's anything else that's relevant other than the Spearman authority.
But obviously that has to be done in conjunction with the claimant. So get an opportunity to comment on it or anything else that they wish to put in as a result. Not encouraging post-hearing researches, but if there's anything that we really think is material that we haven't got, then, as I say, subject to discussing it with the claimant and the claimant being given an opportunity to put in anything that puts it in context, then yes, that can be done.
All right, thank you. And then just finally on practical references, there is a short and elegant summary of the position of the defence of insanity in criminal law in the Law Commission's report. Nobody's taken you to that, but you might just wish to have a look at it.
I'm very familiar with that document, so yes, thank you.
So, and in particular Appendix A on the status of insanity as a defence. And then 3 brief points by way of reply on my part. Ms. Plowden said that the defendants here dealing with Hunter did not apply to strike out on the basis that there was no duty or causation, but only on the basis of ex turpi causa, whereas the key reasoning in Hunter is on causation and breach. I just wish to be clear that we don't say there's no duty here because of the illegality. That's not the analysis. Indeed, we accept in our defence that we owed a duty to the claimant. That's in the core bundle in the defence at page 268, and that's entirely consistent with the analysis in Henderson, where judgment had been entered for the claimant by the time the illegality defence arose. But for all the reasons that I gave you yesterday, we say that the Hunter analysis can be transposed into the modern law of illegality. And second point, it is no part of the defendant's case, as it was not in Henderson, that Mr. Lewis-Ranwell be denied compensation as punishment for what has happened. If that was made clear in the submissions in Henderson and the references in the bundle at page 911 to 2, but that is not the function of the illegality defence as it applies here. And just finally on the resolution of this case, we do invite that there was a strong application by the claimant appellant in Henderson to have the case remitted to the trial judge for the application of Patel if it arose, and that application was resisted by the Supreme Court, who dealt with the matter themselves. They applied Patel, as you saw. And certainly it's our position that you are well able to apply the Patel test in this case. If it had to be remitted to the trial judge, I need hardly say that he or she would then be the third judge to hear these submissions on Patel A and B. And we say, given the dicta of Lord Lloyd-Jones in Stoffel and Lord Hamlin in Henderson about the broad policy approach which should be taken to this, that you're well placed to reach the decision yourselves. My very much a secondary fallback position is that if there are questions pertinent to the facts of the case which need to be resolved as part of the Patel 3-stage test, then stage 3 should be left to the trial judge with you to decide on A and B. I recognise this inherent unsatisfactory nature of that, in that we're splitting up the Patel test, which is patently not what Lord Toulson had in mind in Patel and Mercer, and nor indeed did Lord Hamlin in Henderson. But in my submission, that's more satisfactory than a third judge having to hear again the broad policy arguments about Patel stage A and B. As I say, that's very much a fallback position should you decide that it's not something you can determine yourselves. Those are my only points in reply, unless you have any questions.
Questions? No, thank you very much.
My lady, I dealt with this submissions well in advance.
Yes, well, can we thank all the parties for their submissions in this case? We are obviously not going to give our judgment or judgments now. We will reserve our judgments and the parties will be notified in the normal way. A draft will be circulated for the parties to correct any obvious typographical errors. If you disagree with the reasoning, that's a different matter. It's not for further argument, obviously. If we require any further submissions from the parties, then we would like those in writing, please. And we would also ask the parties, once the draft judgment has been circulated, to endeavour to agree a joint draft order for our approval. It will not be necessary for the parties to attend for the handing down, as that can be done remotely. But I repeat what I said yesterday on behalf of the court. We thank everyone involved, those sitting in the front row, the second and indeed the third row, for all their assistance in this case. We're very grateful to all of you. Thank you very much. All right.